audience and panelists who have joined us today from all over the world for this event, bringing together EU law and policy makers, Brazilian land defenders, and corporate accountability experts to discuss how to improve a new EU draft directive that aims to prevent abuse in EU companies' global value chains. I'm Shruti Suresh, and I'm the strategic lead for the Land and Environmental Defenders campaign at Global Witness, joining you from London. Global Witness is an international NGO that campaigns to challenge abuses of power, protect human rights, and work to prevent climate breakdown to secure the future of our planet. Before we begin our discussion today, I wanted to quickly flag a few housekeeping points. We have interpretation available in English and Portuguese. If you would like to use interpretation, please click on the globe symbol, which appears at the right-hand bottom corner of your Zoom screen. If you're listening in English, please click on the English channel so that when our panelist speaks in Portuguese, you will hear the translation. Alternatively, if you would like to tune into Portuguese, then please click the Portuguese channel. With this, we can kick off our discussion today on a landmark opportunity in the EU to transform business as usual. 2 years after the EU Commissioner for Justice, Didier Reynders, pledged to reset the power imbalance between corporations, people, and the planet, the European Commission published its long-awaited Corporate Sustainability Due Diligence Directive in February this year. This is a potentially groundbreaking directive regulating due diligence requirements for EU companies. Due diligence was first introduced by the United Nations Guiding Principles on Business and Human Rights, or UNGPS, and the OECD guidelines. And it is the process by which companies must identify risks and take action to prevent, mitigate, and publicly report on their actual and potential adverse impacts linked to their operations, subsidiaries, or value chains. For many companies, the primary risk or adverse impacts are internal in relation to themselves. So this is about financial risk, operational, or reputational risks. However, meaningful and comprehensive due diligence is broader, with international voluntary standards referring to the need for corporate due diligence to identify and mitigate adverse impacts on people, the environment, and society at large. This due diligence framework could improve the lives of local communities, many of whom have confronted corporate abuse, such as violent land grabs and environmental destruction. However, to meet its potential, it must reflect the experience of those most affected by the expansion of destructive industries like mining, industrial logging, and large-scale agribusiness. We must recognize how EU companies and corporations accessing the EU single market are linked to harms via their large value chains, and how this law and this directive can work to support these communities. If and only if the EU directive is strengthened, it could achieve its mandate to ensure corporate behavior meets existing international standards and protects people and our planet from harm. It is my privilege to welcome today our excellent panelists, all of whom bring expertise and unique perspectives on both the potential of the new EU law to positively impact affected communities across the globe, as well as the limitations of the current draft text. First, joining us from the European Parliament is Ms. Lara Walters, MEP, member of the group of the Progressive Alliance of Socialists and Democrats in the European Parliament, and Vice Chair of the Committee of Legal Affairs, who's leading the work to develop the Parliament's position on the directive. We're honored to hear from 2 Brazilian land defenders, Ms. Poliane Barbosa Santos Reis, a representative of the Landless Rural Workers Movement, or MST, which is a social movement formed by rural workers championing land reform and social equality in Brazil's rural areas. We also have joining us from Brazil, Mr. José Batista Alfonso, a lawyer for the Pastoral Land Commission, or CPT. For more than 20 years, José has represented defenders like Poliani and her community to secure their land rights and seek justice for criminalization, impunity, death threats, and environmental harms caused by land right conflicts. I would also like to welcome Ms. Barbara Bijelik, the Regulatory and Financial Sector Lead at the Responsible Business Conduct Center, part of the OECD Directorate for Financial and Enterprise Affairs that works with governments, business, and civil society to promote the implementation of the OECD guidelines. Finally, Ms. Lucrezia Busa, the cabinet member of Justice Commissioner Didier Reinders and author of the recently published draft directive, will also be joining us. She sends her apologies as she has been delayed, but we hope she'll be joining us in a few minutes. I'd like to welcome all of today's speakers and thank them for taking part in this event. Thank you also to the audience members who have submitted questions in advance of the event, and we will be answering some of these towards the end of the event. If you would like to ask a question during the event, please type it into the Q&A chat box that you see on the bottom of your Zoom screen and indicate which panelist you wish to direct your question to. If we have time, we will do our best to answer all questions. If not, we would follow up on this after the event. Before we dive into an exciting discussion, of course, we'd like to open with a short video that focuses on the corporate harms faced by communities living in the southern state of Pará in Brazil.
Se você for de Marabá até Paraupebas, você vai perceber uma constância, capim, capim, capim. Toda a área que antes era uma área verde, que era uma área que tinha mato, né? Ela foi toda destruída para plantar capim. E o responsável por tudo isso é o latifúndio. A violência à pessoa humana vem acompanhada da violência à natureza. Quem está na Europa não sabe que consome carne de sangue humano. O bife que está comendo hoje é um bife que custou a vida de um trabalhador aqui no estado do Pará. Quem vive aqui, que está sob ataque todo dia, sabe de fato o que é isso na pele. Né? Sabe de fato que essa violência ela é muito mais brutal do que a violência que é narrada.
As empresas que compram qualquer commodity que venha de áreas de conflito, elas contribuem sim para a morte, para a expulsão das pessoas que viviam ali.
São responsáveis os bancos, as empresas e o latifúndio. Porque a partir do momento que eu compro um produto que eu sei que por trás dele existe violência, desmatamento, e mesmo assim eu vou adquirir esse produto, eu estou financiando a morte das pessoas.
Thank you for watching the video with us, which is a stark reminder of the brave resistance by Pollyanny and her community against corporate abuse. Keeping in mind these real-life harms to people and planet, let's start with some questions for the panelists. Ms. Lara Walters, MEP, as a rapporteur for the Parliament's report on the EU directive, we would like to start with you first and your views on the current draft proposal. Can you tell us a bit about what this law would require companies to do and what it could change for communities affected by business activity worldwide?
Certainly. But before I do that, I just want to thank you for organizing this, and thank you for the beautiful and tragic video that we just saw. And thank you also to Poliana and Jose, I believe, who will be speaking after me, I suppose, and for their amazing work in Brazil. It's good for us. It's hard to see the reality of why we need this law, but it is so important that we see examples such as these to know what we're doing this for, because I think that one of the things that we will need to do is get out of the Brussels conference rooms, at any time that we're discussing this law, so with our minds, go to the situations on the ground that we're actually trying to change. And I think that's the first comment I would make, that we need to make a difference here. It needs to be finished with business as usual once we have this law done, and we need to make sure that there is an impact. And the thing that this law would bring, if we get this right, is of course an end to impunity and greed, and making sure that companies are no longer able to look away, are no longer able to say, but I had no idea that my beef came from a conflict region. And I think that is no mean feat, because we're living in a world that was built for large international companies to be able to make profits. And it was built legally also for them to be protected in whatever they do, rather than being held to account. So sometimes I feel like we're standing on this massive container ship, and we're trying to change its course. And at other times I feel, no, there's such momentum here in the EU now, and we're all so aware of the problems that we, with our consumption patterns, are causing elsewhere, that we will be able to reverse course. Maybe that's just by way of introduction. You can cut me off at any time if you want to move to another panelist, because I'm not sure how much time we have exactly for each segment. But maybe just to flag 3 problems that I see with the law as it stands at the moment, and I'm sure they'll be talked about today. It's great that we have a law on the table. It's great that we have a proposal, but at least 3 things are missing, and there's definitely more than 3 problems. I think that remedy isn't mentioned in the law, and I think that in the case of 2 times the size of Portugal in terms of forests being destroyed, obviously that's something we want to avoid. But if it has been done, then victims of that, land grabs, etc., need to be able to get remedy, and that is something that at the moment is missing. The consultation of local populations, talking to them, and not only at the whims of companies and buyers, but let's say obligatory listening to them. Not only if they see fit, not only if they think that it might be of benefit to them, but making sure that enshrined in the due diligence process is listening to local communities, local trade unions, and so forth. Something that the Parliament put in its draft proposal on this was the reverse burden of proof, because it is so difficult, and I'm sure that Pollyanna and others can say more about this, but so difficult, I suppose, to gather proof, to hold large companies with so much more money and power, I mean even violent power, to account. It's so difficult, I suppose, to get to justice, to make sure that a case can be brought and that it can be won. And therefore I think it's important that we try to reverse the burden of proof for companies to be able to prove that they did everything in their power to prevent abuses. Other than that, I think the problem with this is that I don't immediately see the proposal from the European Commission shifting the responsibility and liability down the value chain to others. I think at the moment there was a fear of what it would mean if we said that companies are now responsible for their entire value chain. And I think the consequence of that was that a compromise was sought whereby companies can still make use of contractual clauses, of compliance verification mechanisms, and so forth, to say that they have done their duty. But if that then means that they just outsource responsibility into the next company down the line, then we're doing exactly what due diligence is not supposed to be. I think what we need is a proactive and serious due diligence duty that places responsibility where it needs to be. And I think that we need to have a very good think about what that means in terms of rewriting the proposal, in terms of responsibility and liability. The worst thing that could happen with this law, I think, is for everyone to feel nice and fuzzy that the EU once again put its money where its mouth is, that we acted normatively, as we often like to say of ourselves, but actually now just making a sort of fig leaf that doesn't change the situation on the ground. That is something I will do my very hardest to avoid, and I will leave it there, and I'm very happy to take any questions or elaborate.
Thank you, Ms. Walters, and thank you for the leadership role you're playing as a watchdog in Parliament to ensure that this law is strong and effective. We really appreciate that. I had a follow-up question on the last sticking point that you mentioned regarding the applicability of the law to the entire value chain. So how do you see this law operating on companies to conduct due diligence across their entire supply chain? For example, the cattle rancher accused of harms towards communities such as Polyans that we saw in the video. Do you see that the current law would apply to such a supplier, or do you envisage potential for the draft law to be amended to ensure that the law can apply for such suppliers?
I think we absolutely have to make sure that companies are responsible for their entire value chain. And I think that that is in line with best practice from the OECD, which already, of course, has a body of rules on this that are widely being followed. But we have to absolutely make sure that the responsibility is for the entire value chain. At the moment, the Commission's proposal talks rather of the duty to perform due diligence to be limited to established business relationships. That is not a concept that has been road tested. I think that is a concept also that immediately raises many questions, because established business relationships would imply relationships where there's, to me at least, where there's already a lot of leverage, when I think it's so important to also try to change things in situations that are further away, that are more difficult to influence, but that is exactly usually where the problems are. So we will need to move away from this established business relationship, and not in the least because that concept, I think, is also open to gaming. I think you can then, as a company, try to not establish any or not enter into any established business relationships, longer term contracts and so forth with companies or with other suppliers, because that would mean that your due diligence duty is reduced. So there is a sore point in the legislation, and one that I will try to amend.
Thank you, Ms. Walters. And that's a really good point, that we do need to ensure there are not giant loopholes in the law that can be exploited by companies. Thank you for your comments, and we'll come back to you, Ms. Walters, in the Q&A as well. If I could move now to Poliani, who joins us from Pará in Brazil. Poliani, since 1988, the Brazilian Amazon state of Pará has lost an area of forest almost twice the size of Portugal, almost all of it driven by cattle ranching. But as you pointed out in the video, violence against people comes with violence against nature. You are part of a community of 1,200 families challenging the expansion of a local cattle ranch onto land believed to be public. Could you talk to us, Poliani, about the harms and some of the threats that you and your community have faced because of your land claim? Poliani, can you hear us?
Olá, podem me ouvir? A tradução tá ruim.
Yes, go ahead, Poliani. Thank you.
A tradução estava ruim, eu não consegui entender direito.
Yes, Poliani, go ahead.
Ok. Mas vou tentar responder a questão. Estão me ouvindo bem? Olá.
Poliani, we can hear you. Go ahead. We can hear you very well. Thank you.
Ok, a resposta. Sobre a questão da violência, né, aqui no estado do Pará. O estado do Pará, ele é o estado que tem altos índices de violência contra os camponeses, né? É um dos estados brasileiros que tem um índice elevadíssimo de conflitos no campo, conflitos por conta da disputa de terras que acontece aqui na região. E esses conflitos, eles têm se acirrado significativamente no último período, né? A gente tem percebido que tem crescido muito aqui na região as ameaças a defensores de direitos humanos, as ameaças às comunidades, né? E, sobretudo, isso tem relação com essa questão da apropriação do latifúndio da terra, né? Da terra pública. O estado do Pará é um estado que tem um índice muito grande de grilagem de terra, que é a apropriação de terra do estado em favor de uma pessoa, de um particular, né? A gente vai ter muitos casos aqui dessa forma em que o fazendeiro, o latifundiário, se apropria, toma posse de uma extensão de terra que é pública, né? Em favor de si, né? E consegue legalizar isso no cartório, consegue documentar isso. E sempre que um grupo disputa, né? Denuncia essa grilagem, denuncia esse aspecto, esse grupo ele passa a ser ameaçado. Então, acontece aqui na região muitas ocupações de terras públicas, e essas famílias, esses grupos que ocupam essa terra, eles são vítimas da violência que o latifúndio tem causado na região. Então, é muito comum várias famílias serem expulsas aqui, né, das suas terras, várias famílias serem ameaçadas pelo latifúndio, e vários defensores também serem perseguidos e serem ameaçados por conta dessa questão da disputa da terra, né? E as violências, elas acontecem de diversas formas, desde a violência direta, né, física, como o assassinato a defensores, assassinato de trabalhadores, torturas, sequestros, até a violência psicológica mesmo, né, as ameaças de morte, ameaças às famílias dos defensores, e também a violência que a gente chama da violência institucionalizada, que são os despejos que são autorizados pelo judiciário aqui do estado do Pará, que é quando a polícia vai até a comunidade e retira a comunidade, né? Destrói as casas, destrói as plantações das pessoas, para que essa terra, que foi adquirida pelo fazendeiro de forma ilegal, novamente volte para a mão desse fazendeiro, para que ele possa produzir carne, né? E essa carne ser vendida para o mercado europeu, sobretudo, né? Então, quando eu relato no vídeo que a carne consumida na Europa é uma carne fruto do sangue de trabalhadores aqui no Brasil, é porque para que essa carne chegue até o prato dos europeus, é necessário que famílias sejam expulsas das suas comunidades, é necessário que famílias percam seus bens, percam sua plantação, percam seu modo de vida seja destruído, para que abra espaço para esse fazendeiro, para esse latifundiário produzir gado, para que esse gado seja comercializado, para que essa carne seja vendida e seja consumida fora do país. Bom, com relação à pergunta, é isso dessa pergunta, né?
Thank you, Polyani, for sharing your experience with us today. I hope that your bravery and leadership serves as a real inspiration for the EU law and policymakers who are listening in as we go forward to discuss the EU law. Thank you very much. And we'll come back to you, Polyani, in the Q&A as well. I also wanted to note for the record that despite evidence of these violations that Polyani has been talking about being documented by a Brazilian parliamentary committee investigation in 2017 and public reporting on these abuses, Global Witness reported that JBS, the world's largest meat processing company, repeatedly purchased cattle from this local rancher, contrary to its commitments to stop buying from any ranchers accused by prosecutors of land grabbing or agrarian conflicts. Despite community claims of human rights harms supported by details in our report, the rancher in question, Rafael Saldana, denied the allegations. We have pasted the responses received by Global Witness in the chat box, including the responses from JBS. Jose, if I could move to you next. As a lawyer and supporter for these cases, such as Polyans, can you tell us how the Brazilian state and local companies have failed to protect the community's rights or provide accountability? Over to you, José.
Olá, sou José Batista, sou advogado da Comissão Pastoral da Terra e trabalho aqui no estado do Pará. Então, a Pastoral da Terra, ela divulga anualmente um relatório sobre os conflitos no campo em todo o país. O último relatório divulgado pela Pastoral, há cerca de um mês atrás, mostrou que, embora os conflitos estejam ainda espalhados por todo o país, é na Amazônia que a situação é mais grave. De acordo com os dados, cerca de 80% dos registros feitos de conflitos, eles ocorreram justamente na Amazônia. Mas não é em qualquer ponto da Amazônia. Os conflitos se concentram principalmente nos estados de Rondônia, Pará, Maranhão, Mato Grosso e Tocantins, que são os estados que estão nessa fronteira de expansão do agronegócio, e o agronegócio principalmente da produção da carne, ou seja, da pecuária extensiva, e da produção de soja, que é um dos principais monocultivos que expande nessa fronteira. E os principais alvos dessa violência, dessa expansão violenta, são comunidades indígenas, que têm seus territórios invadidos, têm seus territórios não demarcados, e não respeitados. São comunidades remanescentes de quilombo, são poceiros, são ribeirinhos, e são extrativistas e outras populações que residem na Amazônia, porque essa expansão do capital em direção à grande Amazônia, no sentido de aumentar a produção da carne, aumentar a produção da soja, aumentar a produção de minérios, acaba confrontando, invadindo territórios, praticando uma série de violências, não só contra as pessoas, mas também contra o meio ambiente. Em relação à violência, por exemplo, contra as pessoas, podemos destacar o estado do Pará. É o estado, como a Poliana disse, com o maior número de assassinatos no campo, em todo o Brasil, com o maior número de casos de trabalho escravo contemporâneo, com o maior número de expulsões violentas, maior número de assassinatos de defensores de direitos humanos e maior número de chacinas de camponeses na área rural. E o Estado também campeão da impunidade. Posso citar um exemplo das 115 lideranças defensoras de direitos humanos assassinadas nos últimos anos só no estado do Pará. Em apenas 17 dos casos houve alguma punição para algum responsável. Se a gente faz um recorte dos últimos 10 anos, das 33 lideranças defensoras de direitos humanos assassinadas nos últimos 10 anos no Pará, apenas 3 casos houve punição de algum dos responsáveis pelos crimes. Então, a impunidade acaba sendo uma regra e acaba incentivando a continuidade da violência. E a impunidade não é só em relação aos crimes contra as pessoas. A impunidade ocorre também em relação aos crimes contra o meio ambiente. Então, quem desmata, quem promove crimes ambientais de toda a natureza, acaba não sendo punidos, acabam não sendo alcançados pela lei brasileira, porque tem influências, por ter um grande poder econômico, tem influências políticas muito fortes no parlamento, no governo federal, e isso acaba impedindo que eles sejam processados e punidos pelos crimes que praticam. Bom, por isso, em razão disso, que nós avaliamos e vimos com muito bons olhos a possibilidade de mudança na legislação que considere essa questão da importação das commodities do Brasil, porque essa expansão violenta do agronegócio e da mineração tem como objetivo principal produzir commodities para exportação. Então, tem que aumentar a exportação de soja, aumentar a exportação de carne, aumentar a exportação de minério a cada ano. E o destino final, geralmente, na maior parte, é o mercado europeu. Então, há necessidade, sem dúvida nenhuma, de ter regras mais claras, ter legislação mais objetivas, ter possibilidade de punição dos infratores, daqueles que produzem no Brasil praticando crimes. Porque isso é importante, porque se dependermos do governo brasileiro, isso não vai acontecer, porque nós temos presenciado nos últimos anos. O governo tem incentivado o desmatamento, tem premiado aqueles que desmatam com a regularização das terras griladas, tem incentivado a garimpagem ilegal em terras indígenas, promovendo não só crimes ambientais, mas crimes contra as populações indígenas, tem reduzido recursos para fiscalização, tem diminuído a capacidade dos órgãos de fiscalização de atuarem e punir os infratores. Portanto, é preciso que haja, nesse processo de importação, no nosso entendimento, é preciso que haja responsabilização das empresas que produzem. Como a Poliana bem explicou, não é possível que o consumidor da carne final não esteja consciente, não esteja assim comprometido com o problema que ela gera nos seus países de origem. Então, é extremamente importante. Me lembro que em 2019 eu estive em umas reuniões em Bruxelas e estava em pauta a discussão do acordo de livre comércio entre a União Europeia e o Mercosul. E uma das questões que nós pautávamos naquela discussão, em 2019, é que deveria ser inserida uma cláusula no acordo que houvesse a obrigatoriedade dos Estados membros, no caso, os Estados dos países da América Latina, de que a produção respeitasse os direitos humanos e respeitasse a preservação do meio ambiente, tivesse condição de rastrear a origem desses produtos, de forma que essa iniciativa de ter uma legislação mais objetiva, de atuação mais célere, mais rápida, é extremamente importante. É preciso não só monitorar melhor a origem dos produtos, é preciso fiscalizar melhor como esses produtos são, vamos dizer assim, fabricados, originados aqui no Brasil e em outros países, e é preciso também ter condições de punição das empresas infratoras. Isso, no nosso entendimento, é extremamente importante. Afinal de contas, ter responsabilidade com as mudanças climáticas é um compromisso, vamos dizer assim, mundial, não pode ser apenas de um ou de outro, tem que ser um compromisso mundial e todos nós, todos espalhados pelo mundo afora, temos que ter consciência disso e nos comprometer com essas mudanças, né? É isso que eu tinha a dizer nesse primeiro momento. Obrigado.
Thank you, Jose. And that was really useful to hear from you on how the EU law could have an impact in tackling the impunity and violence that you vividly described that's playing out in Brazil. And on that note, it would be really good to now segue to Ms. Lucrezia Busa, who has kindly joined us. Thank you so much for making the time. We would like to go to you next, as we understand you have only a few minutes for the event and you'll be leaving us shortly. Ms. Busa, before we get to the questions, I just wanted to say that we wanted to thank you and the Commission for your critical work on the proposal, which we, along with civil society partners, eagerly welcome. As our panelist, Poliani, who's a part of the event today, pointed out in a short film we showed at the start of the event, people in Europe don't often know that the products we consume could be linked to human rights and environmental abuses abroad. This ranges from the beef that lines our supermarket shelves to the soy that sustains our livestock or makes up our veggie substitutes. Ms. Busa, you have previously explicitly emphasized the importance of access to justice for victims of corporate abuse. The EU directive could have an immense impact for communities seeking justice. Could you tell us how communities like Polyans could seek justice and remedy for corporate harms under the directive? Over to you, Ms. Busa.
Hello, good afternoon, everyone. I hope that my video and my audio works because I had some issues in connection. So indeed, thanks for inviting me, and it's a pleasure for me also to participate to the debate and the exchange with you. As you all know, we have presented, the Commission has presented a proposal for a directive on corporate sustainability due diligence in February. I should say that all that I'm saying today is just my personal views and my personal thoughts, and it doesn't bind neither the Commission nor the Commissioner I work for. Let's start from the probably just to explain why we consider this proposal to be very important, and then I'll go quickly to your question. The reason why we consider that it's important is that it addresses a request coming from EU citizens that made it very clear through the debates at national level that led to the adoption of national laws, through the voices of the European Parliament that adopted a report, and through also their direct voice by participating to campaigns in replying to our public consultation that to ask for a framework at the European level that would ensure that European companies address risks of violations of human rights and harm to the environment across the value chain. It is important to say also that our proposal applies to European companies, but also to large European companies. And the reason why we have chosen this scope is that we target the companies that have the highest impact on the economy, that represent more than 50% of the turnover, the total turnover of the companies in the EU, and also therefore have more complex value chains. Complex value chains may carry more risks, and also they have also the means to address these risks. It is important to say that together with large European companies, we're also targeting companies that are not established in the Union, but are active on the European market. And this is because European citizens, they want this measure to be effective and to tackle risks of violation of human rights, irrespective of where the goods come from. They want to be sure that the goods that we receive in Europe are produced in line with the respect of human rights and the environment. And this is, I think the previous speaker was saying, we are conscious that value chains are very complex, that the services and goods that we receive in Europe go through different steps across different countries. And as citizens, we would like to ensure that all these steps and the different stages are done in line, do not carry risks of negative impact on human rights and on the environment. And something that is also important is that the aim of this legislation is not to lead European companies to abandon countries with problematic situations, but rather to use the leverage that we have as European society, both European companies as the private sector and the EU public authorities, to work together to improve the living conditions of the people in these countries. And there are two important things to say in terms of the effectiveness of the proposal that we've put forward. The first one is that it applies across the value chain, and the second one is the enforcement mechanism that comprises an administrative enforcement mechanisms, which includes different national authorities appointed by the different member states of the Union, who have to investigate in case they receive a complaint, whether the companies in question are complying with the obligations of this directive. They can do so either on the basis of a complaint or on the basis of their own volition. And they can gather information through also through contacts with stakeholders. And in this sense, the role also of civil society and of communities is important. And then there is the second part, that is the civil liability, which is the important to ensure access to justice to victims, which is also in line with what the UN guiding principles have required, and that allows the victims to ask for compensation in case there is, in case they suffered harm for the failure from the companies to comply with the obligations of this directive. Now, it is clear that the obligations of the directives are obligations of means, so it's an obligation on companies to adopt the appropriate steps, the reasonable steps, and that when we say reasonable, account should be taken of the business context in which the companies operate, on the countries in which the companies operate, and especially on the measures that they have put in place to address the possible risks. And we have included in our draft proposal a series of measures that are very different, include investments, include support, possible contract, possible cascading of contracts, etc. But what is important is also that the company has also put in place some verification mechanism to make sure that these measures work on the ground. And here, in order to ensure that the measures work on the grounds, the role of civil society is key, because it can help companies also to gather information of what works and what didn't work, and also in case and also to better target their actions. So indeed, there is we have a mechanism that provides access to justice. This was very important for us, as I was saying since the beginning. It's based on a civil liability mechanism that gives compensation to the victims, and that completes also a more general public law mechanism that is meant to ensure that the companies comply with the obligations.
Thank you, Ms. Busa. That's really useful to know. And it's really good to hear from you about the importance of working with civil society and local communities as well. So the current EU directive makes several references to stakeholder engagement with affected communities as an action that companies should undertake where it's relevant. In the Commission's eyes, where does stakeholder engagement fit into the overarching due diligence framework? And where is stakeholder engagement not relevant in identifying risks? If you could elaborate a little bit more on what stakeholder engagement entails under the directive, please. Thank you.
Yes, I think the first important step of the cooperation with the civil society and the stakeholders engagement, it relates to the identification of risks. And there the companies, and that's what we know also from a number of companies that came to see us, that's the way they normally develop their programs, their due diligence programs, is to also get in touch with, to gather information from civil society organizations on what is happening on the ground, on possible risks that are identified. And then the second important step is also in the elaboration of the strategy to address these risks, notably of the correction of the corrective measures that should address these risks, like the corrective action plans, etc. And then, because the idea is to gather information both to design these measures, to design the program, to assist the people, to help the people to address the risks, and also to see how the measures have concretely worked on the ground, whether there is a need to upgrade these measures, to adapt them, or to do other things. Also, we provided as a settlement mechanism within with the companies, so the possibility for stakeholders also to flag issues to the companies and to work with the companies to find a compensation for the victims.
Thank you, Ms. Busam. Could you explain a little bit as well, where you spoke about verification, the role of civil society and local communities in there, and what your expectations would be of companies to comply with the EU directive?
It's also to check, for instance, if an action plan has been put and designed by the companies with a number of measures that have should address the risk, like, for instance, a risk to the environment, a risk that also has negative consequences of people's lives. If to check that the solutions and possibly also the investments that have been carried out by the companies to limit the negative consequences on the environment and on people, like, for instance, to address problem of pollution that may negatively affect also the people living in a certain area, have been successful, have been sufficient, or whether in addressing this problem, or whether this was not the case, and then something else or something more needs to be done.
Thank you, Ms. Busa, and thank you again for the critical work you've done and your team on this law, which is truly a landmark initiative, which we welcome. Thank you very much. I appreciate, Ms. Musa, that you may have to step out of the event, but if you can, please do stay in as we hear from the other panelists and enter the Q&A as well. Thank you.
Thank you.
Barbara, if I could turn to you next. So we've heard from our panelists on the potential impacts and limitations of the EU directive. Could you elaborate, Barbara, on what the international standards for corporate due diligence are and where you feel the draft directive falls short of these standards?
Sure, thank you so much, and thanks for having me here today. Maybe just to start, I mean, I think I just want to also recognize and applaud the Commission's effort with respect to this proposal. It really is a landmark initiative, and I want to recognize how challenging it is to translate what have to date been voluntary expectations for businesses to legal expectations. So there is a lot of challenges in that respect, and I think that the Commission is working through that. So often I come to these events and we raise a lot of the issues without sort of recognizing what's been done. So just to start on that note, I work in the RBC Center, the Responsible Business Conduct Center of the OECD, where our primary objective is really promoting and implementing the OECD guidelines for multinational enterprises, which is one of the foundational legal instrument on responsible business conduct where due diligence expectations are tethered. And it aligns with the UN guiding principles and also the ILO declaration for M&Es with respect to due diligence expectations. The OECD has also developed a series of due diligence guidance for business, really elaborating what due diligence is and how it can be practically implemented by business across different sectors, but also in 2018 through a cross-sectoral guidance, which really laid out the key measures and also the key characteristics of the due diligence process that's expected under the guidelines. So those are sort of the standards, and we see that the Commission made really strong efforts to build expectations around those standards and to embed those standards in it. It's quite explicit in that objective, in the preambular language. The measures outlined in the proposal also align with the 6-step framework of the due diligence process. And we've also been engaging with members of the Commission to explain what the standards say, how we see them implemented by business, and sort of where some of the challenging areas are. So I think to a large degree, there's been huge efforts to try to drive alignment. But there have been, a few areas where I think in translating our standards, which are meant to be flexible, which focus on continuous improvement, and most importantly, are meant to be risk-based, when translating that to a legal standard, there's been efforts, I think, with the objective of providing legal certainty, where some of those key characteristics have been moved away from. So for the purposes of my remarks, I'll just focus on the risk-based approach, and then maybe just say a word about climate issues as well. We think that some of the drafting of the Commission's proposal has moved away from this focus on a risk-based approach, which is really for us a central element of what due diligence is about. So we ask companies to really focus their efforts on where real or potential impacts are most significant, and that's measured based on the severity, scope, and irremediable character of the impact to people and the planet. That's kind of the guiding mantra for how due diligence should be targeted, but then also, in terms of also defining how much effort and resources needs to go into due diligence measures. And this has been lost, I think, a little bit in trying to translate this into legal standard. One area we see that in is this new concept of established business relationships. I think in order to sort of make to concretize expectations a little bit and to orient businesses to where they should be doing due diligence, this concept was introduced, but it moves away from a risk-based approach. So instead of having companies really look to suppliers and business relationships where the highest risk exists, they're oriented to look at all established business relationships where there may or may not be risks, and which may miss actually areas where risks are severe. And that's particularly the case in agricultural supply chains where spot markets and short-term transactions are common. It can also incentivize companies to move away from developing established business relationships or more long-term business relationships, which in and of itself can pose RBC risks. So we think this framing maybe is not the best and doesn't reflect a risk-based approach. There's also not a lot of clarity on the role that risk-based prioritization is meant to play in the law. So appropriate measures are defined in the definition article of the proposal, and they also are used to condition expectations with respect to prevention and mitigation in Articles 7 and 8. But how prioritization feeds into appropriate measures is not well defined, and it's also not pegged to our rationale for prioritization, which again is focused on prioritizing the most significant impacts. Problematically also, it also links leverage to prioritization decisions. That's been something that the UNGPs and the guidelines have been very explicit about not doing. So a lack of leverage under international instruments does not mean that businesses, are off the hook. Rather, it means they should make efforts to increase their leverage through collective efforts, through engaging on systemic issues to try and make a difference. So it will impact what businesses can do, but not whether they should do something and carry out due diligence on the most risky areas. So we think more clarity around prioritization can help in that respect. I think I'm reaching the end of my time, but just one other thing I would say to that is under a risk-based approach, we also think climate would be a significant risk for more companies. So it's really a shame that it's been left out of due diligence expectations in the law. It's true that our standard, the guidelines, doesn't explicitly include the Paris Agreement. It predates the Paris Agreement and climate expectations in that respect. But we see companies, that have already been implementing due diligence practices, and that's particularly true in the financial sector, determining that climate is a priority issue for them. And given our test for what is a priority, I think that would certainly be true. So we would think that exclusion of climate impacts from due diligence expectations is a missed opportunity, but it also is a little bit incongruous with a risk-based approach we'd like to see. So I'll leave it there, as I know there's other panelists to turn to, but those are just two aspects. I think there could be further improvement, and we look forward to working with the Commission and other stakeholders in refining those aspects. Thank you.
Thank you, Barbara. Just to follow up, and we are nearing the Q&A section, but if you could briefly answer another question on the gaps in the EU directive as it relates to the financial sector, and how we could overcome these to ensure that it applies to investors as well.
Yes, so the applicability to investors is actually a little bit ambiguous because investment institutions and asset managers are actually included in the scope of companies that the law applies to. So in that respect, it applies, but there is a limitation with respect to how you consider value chains, in the sense that they only, as described, apply to lending activities with clients and not equity investments. And that makes sense because when you read the law, the value chain terminology is used mostly in reference to expectations around contractual assurances and cascading, and then verification and assurance against those contractual expectations. So of course, investors don't have contractual relationships with their investee companies. So proposing, expectations around contractual assurances doesn't make sense. But the other aspects of the law that are not, directly tethered to value chain terminology, things like developing a prevention mitigation plan, engaging and providing support in undertaking that prevention mitigation plan, that potentially is still applicable to investors as we read it, but there's a little bit of ambiguity there. So that's one limitation. The other limitation is that it only applies to business relationships. So that means clients or investee companies that are large in size. So it explicitly excludes clients that are SMEs, which means banks would not be doing due diligence against SMEs, which is a little bit strange and maybe not in line with international standards. The other limitation that's important to flag is that identification expectations are only ex ante. So financial service providers are only asked to identify adverse impacts before they enter into a business relationship with their clients. This, I think, again, is probably motivated by the link to the contractual assurances and contractual relationship, because it'll be at the stage of covenanting where these expectations are outlined, and changing those covenants can be tricky in financial institutions. But of course, our standard asks for ongoing identification, and that it will be especially relevant for liabilities with long lifetimes. Sometimes, investments and financing cover a decade. So there could be a lot of issues that arise in the meantime that need to be responded to appropriately. The last, I think, a little bit incongruous aspect we see with respect to the financial sector is that we see the law applies to large companies and then medium-sized companies in high-risk sectors, which are defined as those sectors where OECD has developed specific sectoral guidances. And we do, of course, have guidance for the financial sector for institutional investors, but also commercial lenders. We'll soon be publishing guidance also on project and asset finance. So I think from just a practical perspective and a principled perspective, we don't see why the sector would be excluded, particularly where we see a lot of venture capital and small private equity firms that have the resources to do adequate due diligence, and they're actually involved in high-risk investment transactions or financing transactions. We think it'd be useful to include them within the scope of the law as well. So that's just a little bit of an overview on that, and happy to answer further questions.
Thank you, Barbara, for the really useful and practical suggestions to strengthen the directive. Much appreciated. Keeping an eye on time, this is a good opportunity to segue into the Q&A section. We received quite a few questions in advance of the events. I can kick off with the first question for Polyani and Jose. Polyani and Jose, we've heard a lot about meaningful engagement by companies with local communities and civil society. What does this kind of engagement look like for you? And what do you think needs to be captured in the EU law to ensure that this engagement that companies do with companies is not just lip service and that it is effective? Polyani, if I could turn to you first for this question, and then to Jose. Poliani, can you hear me?
Sim. Olá. Sobre a interação das empresas com suas comunidades, né? O compromisso. Eu acho que as empresas, primeiro é necessário que essas empresas elas tenham consciência acerca da cadeia produtiva do produto que elas estão adquirindo, né? Então, eu acho que é extremamente relevante e importante a empresa buscar saber a história da comunidade que está ali por trás, como é que esse produto está sendo produzido, né? Como é que esse produto, por exemplo, a carne, como é que essa carne está chegando, né? Quem é que produz essa carne, por onde que esse processo produtivo ele passa, porque a gente é necessário que essa empresa tome consciência disso para que possa perceber, por exemplo, quem são as pessoas que são impactadas e quais são os impactos ao meio ambiente que esse tipo de produto ele causa. Porque é importante que haja uma reparação, tanto para as pessoas quanto para o meio ambiente, acerca dos danos que são causados pelas empresas que produzem, pelas empresas que adquirem esse produto final. Eu acho que é necessário que essas pessoas, que esses grupos, eles sejam reparados acerca dessa violência e dessas violações de direitos humanos que eles sofrem quando são impactadas pela cadeia produtiva da carne, por exemplo, né? Se a gente pega, por exemplo, uma comunidade que ela foi despejada por conta do avanço da fazenda para a produção de gado, por exemplo, uma questão que fica, né? É o que acontece com essas famílias quando elas são despejadas, né? Porque ninguém sabe o que acontece. Por exemplo, ninguém sabe que a minha comunidade, quando foi despejada em 2017, crianças passaram uma semana na chuva porque não tinham moradia. Que a moradia que elas tinham foi a moradia que foi tirada delas quando elas foram despejadas lá da comunidade delas. Então, é necessário que se saiba disso para que esse dano, essa violência, ela possa ser reparada de alguma forma, para que essas famílias, de fato, elas possam se sentir de alguma forma compensadas por conta desse dano que a elas é imputado pela produção de mercadoria para comercialização no mercado europeu. É isso.
Thank you, Poliani. Jose, if I could put the same question to you on what you'd like to see in the EU law to strengthen corporate engagement with communities. Jose, can you hear us?
Eu consigo ouvir, mas não consigo... Está dando problema na... agora sim, resolvido. Consigo ouvir, sim. Então, sobre essa questão levantada, eu entendo que é preciso ter mecanismos muito claros e objetivos de averiguação dos danos e do contato com as comunidades, me refiro a danos ambientais, e contatos com as comunidades que são atingidas. Falo porque estamos, por exemplo, no caso do Brasil, na Amazônia, uma extensão geográfica imensa. A área de expansão da soja é uma área imensa e a área de expansão da pecuária extensiva também imensa. Então, existem dezenas, centenas de comunidades que são atingidas e muitas delas sequer temos contatos com elas. Às vezes, ninguém tem contato. Os danos ocorrem sem que as comunidades tenham condições de dizer ou de ser ouvidas, ou de ter um contato que possa apresentar uma denúncia, né? Dada a extensão geográfica da Amazônia e dada a extensão da expansão da pecuária extensiva e da produção de de soja, principalmente esses 2 produtos na Amazônia. Então, nesse sentido, que eu entendo que precisa estabelecer mecanismos muito claros de averiguação, né? Porque senão, eu acho que precisa ter também relações muito claras também com órgãos que fazem a fiscalização no Brasil, o Ministério Público Federal, por exemplo, o próprio IBAMA, porque são os órgãos que têm condições, não só têm atribuição de fiscalização, mas condições também de propor ações em razão de infrações ou crimes cometidos, né? Então, eu entendo que a iniciativa tem que ter alguma forma de participação, de relação com esses órgãos responsáveis no Brasil pela fiscalização e pela punição de crimes contra a pessoa e crimes contra o meio ambiente. É isso.
Thank you, Jose. Moving on to the next question, and this is for Ms. Lara Walters. Ms. Walters, some companies claim that it is just too difficult and complicated to map out their value chains. How would you respond to this argument? Because we're hearing this a lot as we talk about the scope of the directive. So it would be good to hear from you on this.
Yeah, the answer I often give is that if a plane were to crash, and I'm sorry for the unpleasant example, but then I don't think anyone would accept an airplane company or an airline to say, well, we have so many different components going into a plane. We have no idea where that faulty screw came from, or we have no idea why the wiring was installed in such a way that was done by some supplier we don't even know. I mean, nobody would accept something like that. And I think that similarly, we have to say it is not acceptable to say, well, certain things are so complex and and have so many components or parts in a supply chain that it is simply too complicated. Because if companies can do business all over the world, then they are already navigating a lot of complexity. And important to bear in mind here is we're not asking for a perfect score. We're not asking here for companies to have 100% visibility and 100% leverage in all instances. So I often think that these claims are a little bit exaggerated. We do need to make sure, of course, that things are workable, but I think that the exaggeration serves those who feel that this will impact their business models. This argumentation is used. So I think we'll be able to convince those who are making this argument with these arguments, but also with the ones, of course, that many companies are already doing this, following the very workable OECD guidelines and so forth.
Thank you, Ms. Walters. And a final question before we close to you again, Ms. Walters. So we're all quite excited about the new law. We want to make sure it's effective and we want to see it up and running soon. Could you talk to us a little bit about the timelines that we're looking at right now in the European Parliament? Which committees will be co-leading on the due diligence? What happens next?
That's a work in progress at the moment. So it's difficult for me to say, as negotiations are ongoing, that I myself plan to make a real start in this process from about September. And I think that the rest will then fall into place. But it's difficult for me to say at the moment.
Thank you, Ms. Walters, and hopefully it's expeditious, and we look forward to working with you and others to ensure that it happens quickly. And thank you again for your efforts. Looking at time, and I'm afraid we will have to end the Q&A session. For the questions that we weren't able to answer, we will do our very best to follow up and answer these after the event. Thank you very much for the audience for putting in these questions. I'd also like to take a moment here to thank each and every one of our panelists, as well as the audience, for joining us today and for making this an interesting and exciting discussion. We look forward to a strong and effective EU law being adopted and implemented expeditiously. If you'd like more information on the proposed EU directive and how it can be used to hold companies to account, there's a link to the Global Witness position paper on this that has been pasted in the chat box. Additionally, please feel free to join us for our next event on climate and due diligence on the 8th of June, hosted by WWF, Global Witness, and Client Earth. Details have also been posted in the chat box. Thank you very much again for making the time to join us for the event and looking forward to all the work that needs to be done in the future. Thank you.